Hello, and welcome to Adapt of Chicago Productions, Chicagoland's only television program devoted exclusively to disability issues. I'm Joel Margolis, your host, and with me today is Mr. Barry Taylor, an attorney for the organization Equip for Equality. Barry, I understand that Equip for Equality has filed a lawsuit against the Chicago Police Department that is attracting quite a bit of attention, and that will be our focus today. But before we discuss the lawsuit per se, could you tell our viewers something about Equip for Equality, when it was founded and what its mission is?
Sure. Thanks very much for having me today.
It's our pleasure.
So Equip for Equality is what's called the Protection Advocacy Agency for the state of Illinois. Every state has an agency like ours, and our mission is to advocate for the rights of people with disabilities, providing free legal services on issues that are related to their disability. We've been the Protection Advocacy Agency for the state of Illinois since 1985. We have about 52 staff members, 28 attorneys, and 4 offices across the state, with our main office here in Chicago.
And for those who want more information about Equip for Equality, do you maintain a website?
We do. You can just go to www.equipforequality.org, and all the information about our organization and the work we do is right there.
Now, I understand that this lawsuit is filed against the Chicago Police Department, alleging mistreatment of disabled individuals by the Chicago Police Department, okay? Before we go into the specifics of the lawsuit, I'd like to know, does this lawsuit have a predecessor or some kind of legal background that formed part of a backdrop to this suit?
Well, what happened is it's been in the news lately, is there have been a lot of concerns over the years about the police department in Chicago and its use of excessive force. There was a task force on these issues that was brought in 2016 that issued a report, and then also the U.S. Department of Justice issued a major report in January of 2017 looking at issues involving the police department and excessive force.
Now, issued in January of 2017, that was before the Trump administration actually took office?
That's correct. And so this was frankly a scathing report about the use of excessive force by the police department. And the hope was that then the Department of Justice would work to implement all the recommendations in the report itself. However, under the current administration, they have elected not to move forward with that report.
So, as a result, or at least partially as a result, Equip for Equality has filed this lawsuit against the Chicago Police Department.
Right. Well, there's actually 3 lawsuits that have been filed, and I think the context is important. So, the first lawsuit was filed earlier in the summer, in June, and that was by a coalition of groups that were concerned about the issues related to race. So, Black Lives Matter, the Mandel Legal Clinic, and a variety of other groups filed a lawsuit against the city of Chicago with respect to excessive force and race and ethnic issues. And then, as people probably saw earlier this year, a lawsuit was filed by the Illinois Attorney General's office, not the federal Attorney General, but the Illinois,
but
Lisa
the state.
Madigan. Right. And there was a press conference that talked about how the Illinois Attorney General was filing this, but doing it in collaboration and cooperation with the city of Chicago, with the goal of putting together a consent decree to address those issues. The reason we filed our suit, and again, our suit was filed by the lead counsel is the ACLU of Illinois, and Equip for Equality is co-counseling with them, and we filed on behalf of 5 different nonprofit organizations. The reason why we brought our case is if you look at the first 2 cases that I mentioned, neither of them focus on the issue of excessive force and people with disabilities. They talk primarily about issues involving race and ethnic origin, which obviously are very, very important. But the Department of Justice report, as well as the Police Task Force report, talks specifically about the issues arising for people with disabilities and how important that was to be addressed. And because these lawsuits that were filed previously did not focus on people with disabilities, we thought it was vital for people with disabilities to have a seat at the table and that our issues be front and center, and that's why we filed the lawsuit.
Now, you mentioned that other organizations are involved in this as well. Could you tell us what are these other organizations that are either named as plaintiffs or are supporting the lawsuit?
Right. So there are 5 organizational plaintiffs that talk about how their members have been adversely impacted by excessive force by the police department. One is called Communities United, Another is Community Renewal Society. Another is One Northside. Another is Next Steps, which is a self-advocacy organization for people with mental illness.
Right.
And then the ACLU of Illinois, because it is a membership organization, also is serving as a named plaintiff, an organizational plaintiff, as well as serving as co-counsel with Equip for Equality.
Now, in filing this complaint, you are alleging mistreatment of disabled individuals, and I'm sure that you have heard some striking stories about mistreatment. For the benefit of our viewers who might not be familiar with some of the specifics of this issue, would you mind sharing with us a couple of the stories that you have heard about mistreatment of disabled individuals by the police department, either with mistreatment of the mentally disabled or other disabilities?
Certainly. And I mean, I think the highest profile case that's been in the news in Chicago is Laquan McDonald. And that's the one where we had the videotape of the young man who was shot by the police. His history as a person with mental illness. He had post-traumatic stress disorder as well as other serious mental illnesses. So he's somebody who people may not have realized had a mental illness. And if the police had engaged with him in perhaps something like crisis intervention training, which is a way to address people who are in crisis as opposed to resorting to excessive force as the first option, we may not have had this tragedy that was so nationally renowned.
And if I remember correctly, he was shot 16 times?
Multiple times. And I mean, the video speaks for itself, and obviously that spurred a lot of the activity that went when that was put out in 2015. But his case is obviously a very extreme case, but there are numerous other cases and instances that are cited in our complaint. And it's important to note that while people with mental illness certainly are oftentimes the subject of excessive force by the Chicago Police Department, there are other disabilities as well, as you alluded to. So we have an example in our complaint involving a young man with autism. And when he was approached by the police, he didn't respond quickly to their instructions, partially because of the issues of how he needs to process information. It takes him a little longer. And because he wasn't responsive, they thought he wasn't being compliant and they shot him. Another example, which is maybe less extreme, but I think very common, is the police interaction with the deaf community. Oftentimes the police don't realize that they're not trained well to recognize somebody is deaf, and they'll immediately handcuff them. Well, in doing that, you're taking away that person's mode of communication. So we have an example of somebody who was handcuffed immediately and unable to communicate with the police and respond to their questions because his hands were behind his back.
And this was someone who relied primarily upon signing as his form of communicating.
Absolutely. And so one of the things that our complaint asks for is for the Chicago Police Department, the City of Chicago, to put extensive training for their officers, for their management, for their supervisors, so that people can recognize the different types of disabilities that people might have, and then once those disabilities are recognized, respond appropriately. You know, the ADA talks about how you're supposed to make accommodations for people with disabilities. Well, this is an example of how that could be done. You don't do business as usual when somebody has different issues that arise because of their disability. You need to modify your policies, modify your practices in order to make sure that you're interacting with them in a way that's appropriate and also that's safe.
Now, I have read that at the national level, it is estimated by some research organizations that about 25% of those shot by the police in urban police forces in the United States are mentally ill. Did the evidence that you have suggest that the incidence of that in the Chicago Police Department is more or less the same, or is it strikingly different to the best of your knowledge?
We anticipated it's about the same. What we don't know is because the police department does not necessarily keep records on whether a person has a disability or not. And so that's one of the things that hopefully will be part of a result of the lawsuit, is that will start being something that is kept accounted for, and then that can be a basis for determining training and staffing and that sort of thing. But I can't imagine that Illinois or Chicago would be any different than the national figures, and you're right. It looks like about a quarter of the folks, when we talk about national numbers, do have mental illness, and then there's also studies, and these are reflected in our complaint, that somewhere between a third up to a half of people have some type of disability, whether it's mental illness or other type of disability. So disability is very prominent in interactions with the police. And so when we're talking about interactions with the police and a police department that has a history of excessive force, by and large, you have to know that that means a lot of excessive force encounters are happening with people with disabilities here in Chicago.
Have you also had cases involving the Chicago Police Department and alleged mistreatment of an individual who was in a wheelchair?
Well, we don't specifically mention those in our complaint, but over the years, Equip for Quality has gotten calls from people who have had issues with respect to accommodations that haven't been provided by law enforcement. Whether we've had specific cases involving excessive force or not, I don't recall off the top of my head. But certainly what we want to do with this lawsuit is to address the needs and issues that are facing people with all disabilities: mental illness, developmental disabilities, communication disabilities, and people with mobility impairments as well.
The whole spectrum of disabilities, in other words.
Of course, why do it piecemeal? We want to get everybody covered by this, these changes that we're promoting.
Now, you have filed this lawsuit, okay? But I wonder, where does it go from here? I think many of our viewers, when they hear lawsuit, picture something such as a courtroom with something like a television drama involving Perry Mason taking place. In reality, in a lawsuit of this sort, what is the next step that happens?
Right. So once we file a lawsuit under the federal rules, the party we've sued, which is the City of Chicago, they have 20 days to file a responsive pleading, which means they can either answer our allegations or they can ask the court to dismiss it, saying that what we've brought is not a legally sufficient complaint. Now, while the rules say that you have to respond in 20 days, typically, especially in a complicated case like this, oftentimes the other side will look for an extension of time. So the 20 days has not yet run for our particular case that we filed. So it's possible the city could answer or file a motion to dismiss, or they could ask for additional time. We just don't know yet.
You mean there is a possibility that the city could file a motion arguing that the case should be dismissed?
That's correct. So that's not really going to our factual allegations. It would be saying that they do not believe that we have a legal basis to bring our lawsuit. And so that's typically something that some defendants try to raise to avoid getting to the underlying facts. Whether or not the City of Chicago decides to go that route or not, we just have to wait and see.
Okay. Now, once they request an extension, in a case such as this, is it likely that the judge would give them extended time to respond?
Well, it's really up to the judge. There's no hard and fast rule on whether an extension should be granted or how long that extension should be given. Typically, if you do have a rather complicated case, and this is one of those kinds of cases that has a lot of allegations and facts and legal theories, it's not unusual for a judge to give the defendant some additional time.
Now, assuming that they respond challenging the allegations, you mentioned that there's the possibility of depositions. For those of our viewers who are not familiar with the legal process, would the depositions be something such as calling disabled individuals who feel they've been mistreated by the police to give testimony in front of a judge or some similar officer of the court?
Well, the depositions aren't typically in front of the judge. They're usually held in the offices of one of the parties. And typically what you're going to have here are witnesses, or you would have people who have information about the underlying issues. So, for instance, I mentioned the 5 different organizations that we've talked about. So they might want to, the city might want to have a deposition and learn more about how their members have been affected by excessive force. We, on the same token, would want to talk to leadership within the Chicago Police Department, and if there are specific instances, perhaps officers that were involved in those specific instances, people who might have information about how they gather complaints, people who might have information about how the police department goes about training. So anything that goes to the underlying lawsuit, the different sides would have the opportunity to request that deposition, and then that's basically an interview where the opposing counsel has the opportunity to ask questions that are relevant to the complaint. It's done under oath. And then those responses, sometimes admissions, are then things that could then be used subsequently at trial.
Now, you mentioned the idea that disabled individuals might be deposed in a process such as this, but you also spoke about members of the staff of the police department. Is it possible here that Equip for Equality or the ACLU would want to depose and interrogate things such as officers who were actually involved in the arrest of a disabled individual?
Right. Now remember, this is a civil case, not a criminal case, so we're not interrogating anybody, but we are asking questions. And typically what you do when you're doing the discovery process is the other side has to disclose who they plan to call at trial. So perhaps the city would say, we want to call the head of our training to show how great a job we're doing training police officers on people with mental illness. And we would say, well, before we get to trial, we want to depose that person to understand what the basis of their opinions are, what they might testify at trial, and really discovery is trying to give you a preview as to what would actually happen at trial. Like you said, on TV, it acts like it's the first time you've heard anything, it's the first time the person's been interviewed or asked questions in the courtroom. The discovery process actually all happens before the trial. We get a lot of information before the trial, and then the trial proceeds after the parties have gotten a better understanding the other side's position and what their witnesses would say.
Now, if this case actually goes to trial, okay, will there then be a trial in the sense that most members of the public understand a trial before a judge with attorneys representing both sides of the argument in a courtroom, so on and so forth?
Exactly. And of course, the judge has the right on how to let the trial proceed. So, she may decide whether it's open or closed or that sort of thing, but typically trials are open to the public, and the parties have the opportunity to answer and ask questions and that sort of thing. I mean, I think one of the things that we want to be clear, though, is that our goal is trying to make systemic change for people with disabilities and their interactions with the police department. The Attorney General has talked about negotiating a consent decree with the city of Chicago. And so our hope is that if that's actually going to be the direction where they go, that we have an opportunity to be part of that discussion, and that the issues of people with disabilities interacting with the police are front and center, and that our issues are part of a consent decree, because what we don't want to happen is some agreement to be reached between the state and the city, and the issues that are important to people with disabilities not being part of that. So hopefully with us bringing the lawsuit and raising these issues, we can be incorporated into that negotiation process, and once a consent decree is negotiated, then there would be enforcement opportunities if the city didn't live up to their agreement.
Now, if a consent decree is given, okay, would the consent decree then set out a series of steps that the police department is subsequently required to take?
That's correct. So a consent decree is different from a settlement agreement. People might recall, oh, the case settled. Typically with a settlement agreement, you reach an agreement and that's it. The court dismisses the case and then the parties work it out. And if somebody doesn't comply with that, you have to go back to court and file a new action. A consent decree says this is so important that the court is going to retain jurisdiction. They're going to keep hold of this case and make sure the parties do what they agreed to do. And so that consent decree is obviously the goal, because you'd like to have the court oversee and be able to address any problems that arise. And so while a lot of times people feel like, wow, we reached an agreement, that's an important step. It is an important step, but there's a lot that has to go after that, because a consent decree we anticipate would be fairly detailed. It would give a lot of requirements. The likelihood the city would have to develop a plan that shows how they will address the allegations and respond to them, including our allegations about how people with disabilities need to be treated in the future and how police officers need to be better trained.
Now, assuming that you do reach the point of a consent decree, could you give us a few examples of specific items that ACLU and Equip for Quality would like to see in a consent decree?
Sure. I think the main thing what we would require is probably some sort of implementation plan, which lays out the principles of how they will actually do the work. Because obviously the principles are important and the goals are important, but we want to actually have a specific step-by-step plan that talks about what they're going to do, what resources they're going to use. So for instance, training is a big component of our complaint, saying that police officers aren't properly trained on how to serve people with disabilities. Rather than just saying that the police will develop a training program, the implementation plan would say, okay, the police are going to hire a consultant who will come in and provide training for police department personnel on something called maybe crisis intervention training, which is a very common training on how to address crises involving people with disabilities, people with mental illness, and other disabilities.
Now, could the implementation plan in a consent decree go to the point of specificity of something such as requiring that professional psychologists be brought in to do some of the training, or requiring that social workers with a specialty in working with the disabled be brought in to do something such as sensitivity and negotiation training? Could those specifics be in a consent decree?
Well, that would probably be in the implementation plan. So the consent decree would be giving sort of the broad outline of things that they need to do, like they need to develop a training program. But then the implementation plan would likely go into the more specific things. The great thing about a consent decree and an implementation plan is it really is up to the parties on how they're going to work to address the problem that has been identified. And then if the parties can't agree, sometimes the consent decree will have something called an independent monitor. And that person is usually somebody who would have expertise on issues like disability and law enforcement issues. And that person really serves as the eyes and ears of the judge to make sure that the parties are doing what they said they would do under the consent decree. And oftentimes you go to that monitor first to resolve the issues, and then if the monitor can't reach a resolution, then you're able to go to court and do what's called a motion to enforce the consent decree. But oftentimes judges like to have that monitor to be the first person that the parties go to when they can't agree on issues. And oftentimes the monitor can also help entities and defendants like the City of Chicago to improve based on experiences they've had in other jurisdictions.
Well, what's to prevent even a consent decree from being dragged out for years and years and very little being accomplished? Will there, for instance, be time requirements in an implementation plan?
Certainly. Time requirements are very important, and oftentimes the consent decree will have time requirements as well. So again, these are all things that are negotiated. But for instance, we have a case involving people with developmental disabilities who are in institutions to live in the community. That we reached a consent decree with that under the Olmstead Community Integration under the ADA. And under that provision, the state had 9 years to put together a plan and to start moving people over the years. And then at the end of that 9 years, then they would move to say that they are in substantial compliance with the decree.
And for the benefit of our viewers who might not be familiar with the Olmstead decision, I believe that was a Supreme Court case in 1999 in which the Supreme Court ruled that disabled individuals must be integrated into the mainstream insofar as possible in the delivery of public sector services.
That's correct. So the Supreme Court, people oftentimes refer to the Olmstead decision as the Brown versus Board of Education for the disability community, meaning that separate should never be considered equal. And the Supreme Court specifically said that unjustified institutionalization is a form of discrimination under the Americans with Disabilities Act. And so that case really provided the impetus for a lot of people to advocate for more integrated services for people with disabilities, including here in Illinois.
I have a hunch many of our viewers, if they are members of the disability community, would like to know, is it possible that disabled individuals themselves would be hired to do some of the training of Chicago Police Department officers?
That's very possible. In some of our other consent decrees, we've used peers to help with the outreach efforts and with the education efforts. So in our Olmstead cases, we've had people with mental illness who lived in institutions who have been part of the process of informing people about their rights under the ADA and the right to live in the community. So I would see, if this is a case involving training and implementation, that it makes sense to consider having people with disabilities be part of that process, since they know better than anybody else what it's like to be involved with excessive force because of their disability.
And I have a hunch on that point, we've just now heard a very loud chorus of amen from thousands of disabled individuals.
Well, I think that's really why we brought this case. We wanted the voice of the disability community. We wanted the issues that are important to people with disabilities to be up front and center. Because otherwise, if we're just talking generally about some of the issues that were raised in the previous lawsuits, and people with disabilities aren't part of that integral part of the implementation plan and the consent decree or whatever resolution we're having, we really haven't done our job.
Now, in a case like this where there is a lot more to be learned, many of our viewers might be asking the question, how do they keep themselves up to date on this case?
Well, both the ACLU and Equip for Equality have websites with information. So it's aclu-il.org or equipforequality.org. If you go to our website and type in police, you'll go right to the page that has the press release, and at the bottom is a link to the complaint.
And that will give the updates as to whatever is happening.
Right. We'll keep updating as things progress. Right now, you have the information about the complaint because that's where we are so far.
So we all need to stay tuned for further action in this drama.
I think there's going to be a lot of action, and hopefully the results will be very positive for people with disabilities.
And I'm sure that thousands of our viewers would join me in wishing you all the good luck in the world in this case, which sounds like a very important one. I want to thank you for coming in today and speaking with us and being so generous with your time. Again, today my guest has been Mr. Barry Taylor, attorney for Equip for Equality, which is co-counsel in a lawsuit just filed against the Chicago Police Department. I want to thank all of you in our viewing audience for joining us once again here at Adapt of Chicago Productions. And as I'm fond of saying, please come back and join us again on another occasion. Bye-bye, but only for now.